I'm going to go over these 7 advantages, but then I'm gonna throw a curveball at you and then tell you why it doesn't matter with what I do. In California, there are certain potential advantages to being the spouse who files for divorce first. Although these advantages can vary depending on individual circumstances, here are some potential benefits. Number 1, choice of jurisdiction. The spouse who files first gets to choose the county where the divorce will be filed. This can be strategically important as different counties may have different procedures, timelines, and judges with varying attitudes towards divorce cases. So that is true. If you guys live in the same home, then there's not going to be a big change in jurisdiction. If you're in LA County, you can file in your local branch court. So, like for instance, I'm in Santa Clarita, so our branch court would be Chatsworth. But in LA County, you can always file your divorce at the central courthouse. That is the main branch. The branch courts, like Chatsworth, Pomona, Van Nuys, Long Beach, etc., those are just for convenience. As you've probably heard me say, I file all of our cases downtown LA because they have the most courtrooms, most judges, systemized. Their process is the same every time, whereas it can be different throughout the other courts. And I know the folks down there. I used to work down there. I know the timeline processing, and the processing is consistent, as opposed to the different branch courts having slightly different policies or timelines. I was telling you the other day how I can get a judgment approved downtown LA in the same day or next day, approved divorce case, whereas I had a Torrance case take 28 days to get approved. And there was nothing tricky about it. It's just they're either understaffed or what, they lost the case or whatever. But that doesn't happen with downtown. So jurisdictionally speaking, it might be an advantage if you have a contested divorce case. I know that the attorneys, but when I did that 12 years ago, that if they knew the case was going to be contentious or was going to go to trial or had the likelihood of going to trial, they wouldn't want to file at Chatsworth or the branch courts. They'd want to file it downtown. And the reason they would do that is because you get a full-fledged judge at downtown in most cases, as opposed to a commissioner. Most of the branch courts have a mix of commissioners and judges, but I would probably say mostly commissioners. They still have commissioners at the central courthouse downtown at Stanley Mosque, but the benefit there is, say you don't want the commissioner, you can file basically a form that says, I don't want a commissioner, I want a full-on judge, and they'll move you to a full-on judge. They'll move you to a different courtroom. I don't know I think people, maybe attorneys, feel that a full-on judge has more training, experience, makes better decisions or whatnot, but I know that would happen when they know it's going to trial. They would not stipulate to a commissioner. At the end of the day, with what I do, it makes no difference who the filing party is. I harp on this all the time. Usually it's the person that pays me. Usually it's the person kind of leading the charge, if you will, pushing the divorce through. They're the one that wants to implement it and start it. But there's no benefit. You don't get a better decision from court. You don't get a better outcome, because with what I do, you guys are calling the shots. You guys make the decisions. So who the petitioner is and who the respondent is irrelevant with what I do. So maybe there's an advantage here. If I'm sure an attorney would say, yes, there's an advantage to being the petitioner because we get, in this case, choice of filing. But at the end of the day, with what I do, that's not the case. Number 2, and we're talking about potential benefits of being the person to file for divorce. Number 2 rationale, legal preparedness. The filing spouse has likely consulted with an attorney and prepared the necessary paperwork in advance. This can give them a head start in the legal process and help streamline the proceedings. So I can see a point here. I'll talk about the contested divorce cases first. It seems like most people, like with my clients, they have already talked about it. They're both on the same page. They want to go through an amicable divorce. They've talked about many things, maybe even the terms. Maybe they even have a full agreement as far as what they want to do. As opposed to when I worked for a law firm 12 years ago, I think that it was a lot of shock and awe. I don't think people were telling their spouse. I think it was going to be contentious. They went directly to an attorney at that time, and there's no warning, no communication, which we were talking about. And so there is this benefit that like someone who's going to file for divorce, they've probably been thinking about it for 3 months, 6 months, 20 years, however long they've been thinking about filing for divorce. And I found that the other party in many cases has no idea there's even anything wrong in the marriage. So it comes to a complete shock to them. So in this point, the legal preparedness, yeah, you've had time to think about it, digest it. You've already consulted with an attorney, whether you retain them or not. You now have some legal advice to kick things around and make more understanding of what you're going to do. Maybe they've told you to get your finances and start printing out bank statements and getting all the financial stuff ready for when you do pull the trigger. That's done. So yes, you do have that advantage that you are more prepared, as opposed to the respondent who one day at home or work gets served by a process server or the sheriff and says, you've been served, here's your divorce papers. And you're reading through it. You have no clue. You haven't met with an attorney. You haven't had a consultation. You haven't got prepared financially. And you're dealing with the shock of, oh my God, my spouse just filed for divorce and I had no idea. So there is that benefit there. That person is already ahead of the game. Now, on the amicable side of things, that doesn't happen. We don't have a shock and awe. I don't file a case unless the spouse knows that both parties, knows that I'm being hired. I have a initial worksheet for people to provide me their initial information, so we can file names, addresses, date of marriage, date of separation, just the boilerplate. For what we need for the petition. And at the very top of the sheet, of the worksheet, it says, before you fill this out, just know that within 30 minutes to an hour after submitting this, I will be adding your spouse to our communication system, our portal, and sending out a welcome email, bringing everybody into the loop. So we don't want that shock and awe. We don't want them to be surprised. So make sure they know before you fill this out. Total different approach with what I do. Number 3, control over timing. By initiating the divorce, the filing spouse can have some control over the timing of court hearings and negotiations. This can be advantageous if there are time-sensitive issues, such as the need for temporary support or custody orders. So this won't have any bearing on with it being an amicable divorce, but from a contested divorce case, there's some truth to this. And I'll give you an example. Let's say you're not receiving any spouse support or child support. You guys have separated, and it's kind of one of these ugly divorce cases we would see when I was working at the courts or with a law firm. And you need to get support. You need to get money coming in. Well, as the petitioner, you can decide, hey, I'm going to file. I'm not going to wait and drag this out because nothing's happening. You can file for divorce, and then you can request a hearing on spouse support, file a motion, it's called a request for order, and get a hearing in about 45 days and basically say, I need, spouse support, child support, custody orders, etc. So you do have that advantage of being able to do that. Now, you can't file to get a hearing without having filed for divorce. I guess you could, but it wouldn't make sense to do that. As the respondent, you can still do that, just not until you've filed the response and you've been served. So petitioner files, they can open up with a motion, to get these temporary orders, get a hearing in place, and then you are then responding to that. So I'm sure, if there's some attorneys listening to that, they're going to say, Tim, stay in your lane. You're not an attorney. You don't know this litigated part of it. They'd probably say there is a benefit to being the filing party, especially when it comes to filing a motion, because you get to write your initial declaration and say, here's what I want and why. And that gets filed. They issue a court date. You serve your spouse. They read it. They get to respond to what you wrote. And they're going to read through what you said and why you want what you want. And then they're going to respond to what you wrote. And then you get one last reply. So you get kind of two at bats on the same hearing, whereas the respondent in a hearing only gets one. So that's where that would make some sense or some advantage to the petitioner. But again, with what I do, it makes no difference. Number 4, psychological advantage. Being the first to file may give the impression of being more proactive and prepared, which can sometimes affect negotiations and the perception of the court. Again, I work for the courts. There is no perception. They don't make those judgment calls because you're the petitioner. Maybe you just feel that that psychological effect. Maybe you were the even though, we don't need to, there's no reasons that are stated for the divorce, but maybe you're the aggrieved spouse, so you want to be the one that files. I've had people say that to me, even though we're doing it amicably. I'll tell them, hey, it doesn't matter who the filing party. And they're like, well, I want to be the filing party because I want the divorce and my spouse doesn't. And I'll have the same opposite effect where the response is, yes, we're amicable, but I don't want this. I'm going to do it amicably. So I'm not going to be the filing party because I don't want this. So it's just psychological or just a personal opinion or decision that's what they want to do because they don't want to be the party filing. But from a other than that, there's no advantage, just personal preference in that way. Number 5, temporary orders. Oh, I guess I kind of jumped the gun on that. Temporary orders. The filing spouse can request temporary orders for child custody, child support, and other matters soon after filing. These orders can help ensure financial stability and well-being and child well-being during the divorce process. So I kind of mentioned that already, but that is the case. Just because you're the respondent doesn't mean you can't also do that. Let's say your spouse files for divorce and then nothing happens, because nothing happens with the court. You file, you get served, you have 30 days to get your response in. But other than that, the court doesn't even know you exist. There's no hearing set. There's nothing scheduled. They're just until you ask for help, until you file a motion to get a hearing, until you enter the actual court system on their calendar, nothing happens. So if you filed for divorce and you served your spouse, and then your spouse files a response, they can immediately file a request for all of these requests: child support, spouse support, custody orders, whatever you think you need temporary orders for. And why would you do that? It's so you can get temporary orders in place pending the final divorce date. We don't have to do that with our clients. Our clients aren't going to court at all for their entire divorce ever. And they don't need temporary orders because we usually have their permanent orders in effect, the settlement agreement drafted in a couple of days, couple of weeks, at most a month when we submit it, and then it's approved by the judge and you're done. So we never have to have temporary orders put in place. But why would you do that? Because if you're going to trial, if you have attorneys, what we do in a month is probably taking a year at minimum with the court for you get actual court dates and get in the system. And if you have to go to eventually having a long cause or a short cause trial, it takes a long time to get there because there's several steps that happen before that, before you ever will have a actual trial. You're going to have forced mediations, forced 4-way meetings. You're going to have all of your discovery done. A lot of steps that go into play before, probably 3 hearings or 4 hearings before you ever have the trial. So it could be a year out easily. So that's why you might want to get temporary orders for spouse support and child support, custody, and any other issues you might have up until the point you guys have that final trial. Number 6, momentum and initiative. Filing first can set the tone for the divorce and may convey a sense of initiative and control, can help shape the narrative of the case, especially in terms of framing issues and presenting arguments. So yes and no. Again, with what I do, this doesn't come up as an issue, but for those of you maybe going through a contested divorce, I suppose there's some power, if you will, or control, if you will, of being the petitioner. In the end, you guys have equal access to attorneys, to filing all the same motions and so forth. But you can be the one to decide to file. You can be the one to lead the charge. But again, it's not a huge difference in this case between the petitioner and the respondent, as far as what I can see. And again, it has nothing to do with what us doing as an amicable divorce is not going to ever be an issue at all. Number 7, familiarity with the process. The spouse who initiates the divorce may have a better understanding of the divorce process, which can be beneficial in terms of navigating the legal system and making informed decisions. And I think this might go back to number 2, the legal preparedness. It's that you have that opportunity to consider what you're going to do initiate with a consultation with an attorney. Maybe then you, like the client or the consultation I had today, she consulted with an attorney a month ago, still hasn't pulled the trigger yet, deciding on whether to use an attorney or not, or use us if they're going to be amicable. But she was able to consider all of this. The consultation we had went on for about 25 minutes. And when we were talking about all the various aspects of the divorce, custody and child support, spouse support, selling of the home, their pensions or 401ks, she had carefully considered all of these options of what she thought she would like to do as far as an agreement goes. So when she goes to now speak to her spouse, he may not have considered any of this and is being hit with all this information. So a little lack of preparedness there because you weren't expecting to have that conversation just yet. Maybe you didn't have a consultation with an attorney yet, and you have to, and now all of this is kind of thrown in your lap, and it's legalese, and you're being sued, and you're being served, and you're getting warning, notices from attorneys, and all these threatening things about don't change, what you can and can't do on the summons and so forth. So I could see, if you have that shock and awe, that you wouldn't want to be on the receiving end of that. That's why I focus on the amicable stuff. No shock and awe, as I keep saying, no surprises. Everyone's on the same page. I mean, I'm the guy saying don't file until you've talked to your spouse. You'll never hear an attorney say that because first of all, they're afraid if you don't hire them on the spot, you're going to go have another consultation or hire someone else. They're afraid that you'll go and hire someone else. So they're going to push you to retain them. They're not going to have any care or consideration on whether or not your spouse gets served at work, at home, at the worst possible time. In fact, the more they can stir the pot, I'm sure this is not all attorneys, but the more they can stir the pot, the more contested your divorce case can be. Going back to the gal I was talking about, I had a consultation with today. I believe she did say her husband did talk to an attorney, but that he got a bad feeling from them because that he was talking, hey, we want to make it amicable, but the attorney was talking, giving him the impression that it wouldn't be amicable no matter what, and that he felt that the attorney's advice and things he suggested they do would put them down this path, taking them straight to court. Why do they do that? Again, not all attorneys, but they don't make money on an amicable divorce. Why take an amicable divorce and maybe charge, $2,500 or $5,000 when they can make 30, 40, 50 grand by taking it to trial? That's an unfortunate truth. I think you need to carefully consider, just don't, you hire an attorney to say, hey, they're going to save me. They're going to protect me. They are, but keep in mind, you have someone charging you hourly fees. The more aggressive, quote unquote, they are, the more costly your divorce is going to be. So in wrapping up, it's important to note that while these potential benefits exist, they do not guarantee a favorable outcome in the divorce. Ultimately, the outcome will depend on various factors, including the specific circumstances of the case, the cooperation of both spouses, and the judge's decisions. Regardless of who files first, it's often advisable for both spouses to seek legal counsel if you're going to court for sure, or have someone that is a neutral third party like me who will help you guys get through this amicably. You will be the ones to decide if the agreement is fair because you guys are providing that to me. I'm not making the decision. The court's not making the decision. No attorneys make the decision. Court will not get involved in the decision making. I do believe going this route is the best way to go from any perspective you can think of, from a cost, from a timeline, the speed of how fast we get it done, to you guys getting to make the decisions. Nothing's getting taken out of your hands. Can you imagine these people that go to trial over custody issues because they're fighting? Whatever the judge decides is what the rule is, regardless if you like it or not. You want A, your spouse wants C, but you're going to get B, and neither of you are going to be happy. That's how that's going to go through in court. So figure it out on your own. It's the best way to do things.